Welcome back to the deep dive. This is where we take those dense, kind of technical documents and we'll make them stick, make them make sense.
That's the plan.
And today, we're really getting into the foundations, the absolute bedrock of how criminal trials work, how they're decided. We're cracking open Chapter 2 of the Texas Penal Code. It's all about who has to prove what and, how convincingly they have to prove it.
Yeah, it sounds dry, maybe just procedural stuff. But honestly, for the lawyers actually in the courtroom, this chapter is everything.
Like a playbook.
Exactly. It's the blueprint. It tells you, okay, does the state carry this massive weight, or does this specific argument flip the script, put some of that burden back on the defendant?
Okay. So our goal today, and this is specifically for you listening and trying to learn this stuff.
Right.
We want to walk you through the mechanics step by step.
Right.
We want you to get why these labels, exception defense, affirmative defense, why they aren't just fancy words. They're like tripwires. They can completely change how a trial unfolds.
Precisely. That one word in the statute. It dictates whether the prosecution is fighting uphill, trying to hit that beyond a reasonable doubt standard on everything, or if, for maybe the first time in the trial, the defendant actually has to prove something themselves. Usually just that it's, more likely than not.
It's a huge difference.
A world of difference, and we're going to demystify that today.
All right, let's do it. So before we get into burdens shifting around, we need to set the baseline, right? The starting point for every single criminal trial.
Absolutely. You have to start with the foundation. And that foundation is Section 2.01. It lays out the presumption of innocence.
Okay.
And look, this isn't just some nice phrase they say in court. It's the actual legal starting position.
Okay.
Everyone is presumed innocent, period.
That's powerful. It's like a shield, right? From the moment someone's accused.
It is. And the practical effect is massive.
Yeah.
It means the prosecution, they can't win, they can't get a conviction unless they prove every single little piece.
Every element.
Every element of the crime. And they have to prove it to the highest standard there is, beyond a reasonable doubt.
BRD. We hear that phrase a lot.
And it means something. It's the Everest for the prosecution, like you said. If they slip up, if they fail to prove even one tiny factual part of the offense to that degree,
To that level of certainty.
then the whole case just collapses. Defendant walks.
Okay, but here's something I think confuses people. And the law actually addresses this directly, right? The fact that someone's even on trial. Doesn't that kind of suggest?
Suggest guilt. Yeah, it's a natural assumption, but the law forbids it.
How so?
Section 2.01 is super clear on this. It says the fact that someone was arrested
Right.
or indicted by a grand jury or charged in any way,
Yeah.
none of that creates any inference of guilt at the trial. None.
Wow. So the jury's supposed to completely ignore the fact that police arrested them, or a grand jury thought there was enough evidence to indict.
They have to ignore it.
Yeah.
Legally, they have to treat the defendant like a blank slate, like they just walked in off the street.
That's a heavy lift for a jury, mentally.
It is, but it's crucial for due process. The indictment. It's just the ticket to the trial. It's not evidence. Not one bit.
So a prosecutor couldn't argue, well, the grand jury indicted, so...
Absolutely not. That would be grounds for a mistrial, probably. The law explicitly forbids drawing that link. The focus has to stay only on the evidence presented in court.
And whether that evidence hits that super high BRD bar?
Exactly.
Yeah.
It forces the jury to rely solely on what the state can actually prove right there in front of them. No shortcuts. The whole weight is on the prosecution.
Okay, so the state has this huge BRD burden for all the elements. That leads us right into the tricky part of Chapter 2. What happens when the defense says, okay, maybe I did the act, but...
Right, but the law doesn't apply here. Or, I had a good reason, like self-defense.
How does the law handle those counter-arguments?
This is where the labels become critical. The legislature uses very specific phrases when they write these laws. And those phrases, they dictate the entire procedure. Who proves what?
Gotcha. It's all in the wording. So let's start with the first label, exceptions. Section 2.02. If you see this specific phrase in a law, what does it mean? The phrase is, it is an exception to the application of.
That phrase signals something really important. It means the law considers the absence of that exception to be so core to the crime that the state has to prove it's not there.
Okay, wait. The state has to prove a negative. Prove the exception doesn't apply.
Exactly. And they have to do it beyond a reasonable doubt. It basically adds another element for the state to prove.
And there are two parts to this burden, right? A paperwork part and a proof part.
Correct. First, the procedural part. The prosecutor has to explicitly negate the exception in the charging document. The indictment or information has to say, basically, and this exception doesn't apply here.
So they can't just wait and see if the defense brings it up.
Nope. They have to tackle it head-on right from the start. It forces them to think about it during the charging phase.
That's significant. Okay, what's the second part? The proof burden.
That's the trial burden. The state has to prove to the jury, beyond a reasonable doubt, that the defendant's situation, their conduct, does not fall within that exception.
So if the exception does apply, the person isn't guilty under that law.
Correct. Their conduct isn't criminal according to that specific statute.
So going back to that proving a negative thing, it makes the state's job much harder.
Oh, absolutely.
Yeah.
Imagine a drug possession law. But it says it's an exception if you have a valid prescription.
Okay.
If it's labeled an exception, the state doesn't just prove possession. They also have to prove, beyond a reasonable doubt, that the defendant did not have a valid prescription. That's way tougher.
Much harder than just proving they had the pills.
Way harder.
Now, there's a historical note here, too, in 2.02c. This strict rule is relatively new.
Relatively, yeah. This whole system, negating in the accusation, proving the negative BRD, it only applies to offenses written after January 1st, 1974. That's when the current penal code took effect.
What about older laws?
For laws before that date, older common law rules might apply. And often, under those older rules, if a law had an exception, the defendant had the burden to prove they fit into it, like proving they had the right license or permit.
Ah, okay. So the 1974 code deliberately shifted that burden onto the state for these exceptions, made it tougher for the prosecution.
Exactly. It was a conscious choice. The legislature decided it was fairer to make the state disprove the exception BRD, rather than making the defendant prove they qualified for it. It's a big protection for the accused.
It really tilts the scales toward the presumption of innocence, even for these specific carve-out.
Definitely. If something's important enough to be called an exception, the state has to knock it down, BRD.
Okay, let's shift gears to the next category, general defenses. Section 2.03. This is probably what most people think of, right? Self-defense, necessity.
Yes, those are classic examples. And the label here is simpler. It is a defense to prosecution. Just that. No exception, no affirmative.
So what's the first big difference compared to an exception? The paperwork.
Right. The prosecutor does not have to negate a general defense in the accusation. They don't need to say up front, and by the way, it wasn't self-defense.
So the issue only comes up if the defense raises it.
Pretty much. It's reactive. Section 2.03c says the issue of the defense only goes to the jury if evidence supporting it has actually been presented in court.
Who has to present that evidence?
The defendant. They have what's called the burden of production. They need to put something forward. It doesn't have to be overwhelming, just some credible evidence that raises the possibility of the defense.
Okay, this is my shield analogy again. The defendant just has to lift the shield a little bit, show there's some reason to think the defense might apply.
That's a good way to put it. Once the judge agrees, there's enough evidence to even talk about the defense. Even if it seems weak, the shield is officially up.
And once the shield is up, what happens to the burden of proof? Does it shift?
This is the crucial part. The burden of proof doesn't shift to the defendant. Instead, it stays firmly with the state, but in a specific way. Look at 2.03d, the rule for the jury instruction.
Okay. It says, if the issue is submitted, the judge tells the jury that a reasonable doubt on the defense issue means the defendant must be acquitted.
Exactly. That's huge. The defendant does not have to prove they acted in self-defense. They don't have to prove necessity.
They just have to raise enough doubt.
They just need to make the jury think, maybe it was self-defense. We're not sure. If the jury has a reasonable doubt about whether the defense applies, or rather a reasonable doubt about whether the state disproved the defense,
then they have to acquit.
they must acquit. That reasonable doubt benefits the defendant entirely. The state still has to climb that BRD mountain. They have to prove the crime elements BRD and essentially disprove the defense BRD.
Wow. So even when the defendant says, yes, I did it, but I was justified, the state still carries that ultimate high burden.
That's the power of a general defense under 2.03. It keeps the pressure maxed out on the prosecution.
All right, now for the big twist. The category where things really change, affirmative defenses. Section 2.04. And the key word here is right in the name, right?
Absolutely. That single word. It is an affirmative defense.
Yeah.
That changes everything.
How does it start? Same as a general defense, procedurally.
Starts similarly, yes. Prosecutor doesn't have to negate it in the charging document.
Yeah.
And the defendant still has to raise the issue first, produce some evidence. That's 2.04c.
Okay. Same burden of production, Just got to get the shield up.
Right. But once that shield is up, and the judge agrees to instruct the jury on the affirmative defense, look out. Section 2.04d hits.
What does it say?
The judge must instruct the jury that the defendant has to prove the affirmative defense.
Uh-oh.
By a preponderance of the evidence.
And there it is. The burden actually shifts.
It's the biggest shift you see in criminal law, burden-wise. For this one specific issue, the affirmative defense, the defendant picks up the burden of proof.
But it's a lower standard, right? Preponderance of evidence.
Much lower. It's a standard used in civil cases mostly. It just means more likely than not.
50.1%.
Basically, yeah. Think of the scales of justice. The defendant just needs to put enough evidence on their side to make the scales tip, even just slightly, in favor of the defense being true.
Compared to the state needing to slam the scales down BRD for the offense itself.
Exactly. It's a huge contrast in how much proof is needed.
Okay, but hang on. Can the state just label anything an affirmative defense to make things easier for themselves? Like, could they say, proving you didn't intend to do it is an affirmative defense?
Ah, good question. No, there are constitutional limits. The Supreme Court has weighed in on this.
Like what?
Well, in cases like Mulaney and Patterson, the court basically said states can't shift the burden of proof for facts that are actual elements of the crime itself.
So if intent is part of the definition of the crime,
the state has to prove intent, BRD. They can't redefine the crime by calling lack of intent an affirmative defense and making the defendant prove it. That violates due process.
Got it. So an affirmative defense has to be something separate, something that excuses the act even if all the elements are proven.
Generally, yes. It's often about mitigation or excuse, separate from the core actus reus and mens rea. The classic example is insanity.
Okay.
The state proves the defendant committed the act, the shooting, whatever it was. The defendant might not even deny the act, but they raise the affirmative defense of insanity.
Saying they weren't legally responsible at the time.
Right. And they have the burden to prove that insanity by a preponderance of the evidence. They're proving a separate condition, not negating an element the state proved.
Okay, that makes sense. So general defenses, raised doubt, state still has BRD, affirmative defenses. Defendant has to prove it, but only more likely than not.
That's the core distinction. Hashtag D. The safety net of unlabeled defenses, section 2.03e.
Now, what if the legislature writes a new law, includes something that looks like a defense but forgets to label it? They don't call it an exception, a defense, or an affirmative defense.
Yeah, drafting isn't always perfect. The code actually anticipates this. There's a safety net built in, section 2.03e.
What does it do?
It says if a potential ground of defense in a law isn't plainly labeled, according to Chapter 2 rules, it automatically defaults to being treated as a general defense under section 2.03.
Ah. So it defaults to the option that's most favorable to the defendant.
Exactly. The defendant gets the benefit of the doubt, literally. They get that powerful, reasonable doubt on the issue equals acquittal instruction.
They don't get stuck having to prove it by a preponderance just because the label was missing.
Correct. It prevents ambiguity from harming the defendant. It ensures the state keeps that overall BRD burden unless the legislature explicitly shifts it by using the affirmative defense label.
That's a really important backstop. Shows a clear bias towards protecting the accused when the law isn't perfectly clear.
It's an interpretive rule, yeah.
Yeah.
Keeps the system consistent with the presumption of innocence.
Okay, we've covered the elements, the exceptions, the defenses. Now let's talk about something slightly different. Presumptions, section 2.05. These are ways the law kind of guides the jury's thinking, right?
That's a good way to put it. A legal presumption is basically a shortcut. The law recognizes that if fact A is proven, there's a really strong logical link to fact B often being true as well.
And fact A is usually easier to prove than fact B.
Often, yes. Fact A might be an observable action, the evidentiary fact, while fact B might be harder to prove directly, like someone's mental state, the presumed fact.
Can you give an example?
Sure. A common one involves theft. A law might say that if you prove the defendant was found possessing property that was recently stolen.
Okay, possessing recently stolen stuff, that's fact A.
Right. That proof can give rise to a presumption that the defendant knew the property was stolen.
Knowledge. That's fact B, the mental state, harder to prove directly.
Exactly. Possession is the evidentiary fact. Knowledge is the presumed fact. It's a way for the state to bridge that gap.
But section 2.05 treats these presumptions very differently depending on who they benefit, right? The instructions are totally different.
Completely different. There's one set of rules for presumptions against the defendant, and another much stronger set for presumptions in favor of the defendant.
Let's start with presumptions against the defendant. How are these handled? They have to be careful not to mess with that BRD standard, right?
Absolutely. That's why these are treated as permissive inferences. The law suggests the link, but the jury can always reject it.
So when does the judge even tell the jury about the presumption? Is there a threshold?
Yes, under 2.05A1, it only gets submitted if there's enough evidence of the underlying facts, fact A. But even then, the judge acts as a gatekeeper.
How so?
The judge should not submit the presumption if they think the overall evidence clearly makes it impossible for a reasonable jury to find the presumed fact B, beyond a reasonable doubt. The judge has to believe a jury could reasonably make that leap.
Okay. So if it gets submitted, the judge gives specific instructions, 4 parts, right? Let's break those down from 2.05A2.
Okay, first part, A, foundational. The jury must first find that the underlying facts, fact A, have been proven by the state beyond a reasonable doubt. No BRD proof of fact A, the whole presumption thing is off the table.
Makes sense. What's B?
B is the core of the permissive idea. If fact A is proven BRD, the jury may find that the presumed fact, fact B, also exists. But, and this is critical, they are not bound to find it.
They can choose not to.
Absolutely. They can say, okay, he possessed the stolen goods, fact A, proven BRD, but we don't buy the idea he knew they were stolen, rejecting fact B. Maybe they believe his story about finding them or borrowing them innocently.
Yeah.
The jury always has the final say to reject the inference.
That not bound to so find is key for constitutionality, then.
It is. It preserves the jury's role and the state's ultimate BRD burden on the mental state element.
Okay, what's instruction?
C is a reminder. Even if the jury does accept the presumption and finds fact B is true, the state still has to prove all the other elements of the crime beyond a reasonable doubt. Proving knowledge via presumption doesn't automatically prove intent to deprive, for example.
Right. It only helps with one piece. And
D circles back to the foundation. If the jury has a reasonable doubt about whether fact A, the underlying facts, was even proven, then the presumption fails completely. They can't use it at all.
so lots of safeguards. The jury can use the shortcut, but they don't have to, and the state still has to prove everything else BRD.
Precisely. It's a carefully limited tool for the prosecution.
Now, what happens when the presumption works for the defendant? Section 2.05b, you said this is much stronger.
Oh yeah, completely different dynamic. Here, the rules are designed to give the defendant the maximum possible benefit. It becomes a mandatory finding unless the state can decisively disprove it.
Okay, let's look at the instructions under 2.05b2. How does the state fight against a pro-defendant presumption?
They have a tough job. Instruction A says the presumption applies unless the state proves beyond a reasonable doubt that the underlying facts, fact A, the one supporting the presumption, do not exist.
Whoa. The state has to prove the non-existence of the helpful facts, BRD.
Exactly. They have to demolish the foundation of the defendant's presumption with that highest level of proof. It's a very high bar.
And what if the state fails to do that? Instruction B.
Then it's mandatory. Instruction B says if the state fails that proof, the jury must find that the presumed fact, fact B, the one favoring the defendant, exists.
Must. No choice for the jury.
No choice. If the state can't disprove fact A, BRD, then fact B is legally established. The jury doesn't get to reject the inference here.
So even if the state creates some doubt about the facts favoring the defendant, if it's not beyond a reasonable doubt, the presumption kicks in automatically.
Correct. Any uncertainty there benefits the defendant and makes the favorable presumption stick.
Okay. Instruction C is probably the same reminder.
Yep. C just reminds everyone, the state still has to prove all the other elements of the actual offense, BRD. This presumption only locks in one specific fact for the defendant.
And what about D? This sounds like the ultimate safety net.
It really is. Instruction D says if the jury has a reasonable doubt about whether the presumed fact itself, fact B, exists, the presumption applies, and the jury must consider that presumed fact to exist.
So any doubt about the outcome of the presumption forces the jury to rule in favor of the presumption.
Maximal protection for the defendant. If they're unsure whether the beneficial fact is true, the law says treat it as true.
Wow. The difference between may find for the state and must find for the defense is stark.
It's night and day. It just highlights how carefully these rules are balanced, using precise language to control exactly how much power the judge's instructions have over the jury's deliberation, all centered on who carries which burden.
It really drives home that legal language isn't accidental. Every word matters. Hashtag outro.
So let's try to boil this down for you, the listener. If you remember nothing else, remember these 3 labels and what they mean for who proves what.
Okay. First up, exceptions. You see, it is an exception.
Max burden on the state? They have to negate it in the charge sheet and prove it doesn't apply beyond a reasonable doubt.
Got it. Second, defenses. Just, it is a defense.
Defendant raises it with some evidence, lifts the shield. But the state still has the ultimate burden. If the defense creates reasonable doubt about the whole case, acquittal.
Right. Reasonable doubt is the key. And third, affirmative defenses. That keyword, affirmative.
That's the switch. Defendant raises it, but then they have to prove it's true by that lower standard, preponderance of the evidence. More likely than not.
Exception, defense, affirmative defense. Different labels, different burdens.
That's the core takeaway. The specific words the legislature uses, they aren't just style. They are the tactical instructions for the entire trial. You now get the strategy behind those labels.
And thinking about those really detailed jury instructions, especially for presumptions, it does leave you with a final thought, doesn't it?
It does.
We've spent all this time parsing the difference between may and must and proving negatives, BRD. How well can 12 ordinary people, the jury, actually absorb and apply these super technical, multi-part legal rules?
Yeah, how effective are these instructions, really? It highlights that constant tension in the justice system, right? You need absolute legal precision.
But you also need to communicate it clearly to non-lawyers.
Exactly. Getting that translation right, making sure lay people can genuinely apply these complex rules to reach that beyond a reasonable doubt conclusion. That's the ongoing challenge, the system's own burden, you could say.
Definitely something to think about. Thanks for walking us through that complexity today.
My pleasure.
And thank you for joining us on The Deep Dive. We'll catch you next time.